Good evening, everyone. Thank you for joining us today. We at Numen Law Offices welcome you to our first webinar. I'm Lakshmi. I handle the criminal litigation at Numen Law Offices. I request everyone to keep their video and audio turned off during the entire session. Joining us today are our speakers, Mr. Satish Maneshinde from Bombay and Mr. P.K. Dubey from Delhi, to discuss the challenges and hurdles that we may face in criminal trials from now on. Mr. Satish Maneshinde has his offices in Bombay and Delhi. He hails from Dharwad and is a first-generation lawyer. He started his career under senior advocate Bhim Rao Nayak and thereafter joined Mr. Ramjeth Malani's chambers in 1983. During his 37 years of practice, he has represented top politicians and celebrities like Salman Khan, Sanjay Dutt, Bala Saheb Thackeray, A.R. Antole, Vilas Rao Deshmukh, Narayan Rane, Sushil Kumar Shinde, and Chhota Rajan. He has also worked on General Vaidya's murder trial, Adarsh Housing Society scam, 2G case, and the Colgate scam. Mr. Maneshinde regularly appears in the Supreme Court and High Courts across the country. Being a top-notch criminal lawyer, he was appointed as a special public prosecutor on behalf of NIA New Delhi in the Italian Marines case. And I'm extremely privileged to have had the opportunity of working under him for more than 6 years. Thank you for joining us, sir. We also have with us today Mr. Pramod Kumar Dubey from Delhi. Mr. Dubey joined the chambers of senior advocate Siddharth Luthra and worked with late Mr. K.K. Luthra until he set up his own offices in 2007. During his 25 years of the practice, Mr. Dubey has appeared in matters across various courts in India. Some of the notable cases he has been a part of are the Tehelka Commission case, the CWG scam, Coal scam, Augusta West and Chopper case, Cargill Coffin case, INX Media case, to name a few. Being an expert in criminal law, the prosecution has also sought his counsel. He has undertaken various cases from the side of the prosecution, such as the Arushi Talwar murder case, the Gopal Kanda murder case, and the Stock Guru scam. He even represents Delhi police as a special public prosecutor in various cases. His passion and calling has always been in conducting evidence, especially cross-examination. With these two highly experienced lawyers, we are extremely excited to talk about the balancing of criminal trials and social distancing norms, followed by a round of question and answers. We're currently experiencing how courts have completely ceased to function, right from the magistrate courts all the way up to the Supreme Court, because there's absolutely no method of restricting these crowds from entering the premises. Now, in court, we usually see the security guards, the canteen staff, litigants, junior lawyers, their counsels, interns, court staff, clerks, and of course, the judges. So there's always a large number of people required to continue functioning of the courts and conduct any proceeding in the court. And now, unfortunately, we've come to a time wherein social distancing is of utmost priority. Not only now, but maybe till the end of this year or maybe even next year, as and when India gradually recovers from COVID-19. But in the interest of justice, we cannot possibly have courts being shut all throughout like this. So we need to be prepared for when courts do decide to open up. So let us discuss how social distancing is going to impact a criminal trial court in India. Now, in a criminal trial, we have the accused, a public prosecutor, defense lawyers, depending on the number of accused, multiple witnesses of all ages, court staff, your carcoons, who are the link between the police station and a court. Then, if an accused is in custody, a police representative of the jail to bring the accused and of course, your judge. This number in a courtroom itself goes against the principles of social distancing. So how do we go about reducing the footfall when it comes to criminal litigation and at the same time ensuring that the necessary safeguards of a trial provided for under the CRPC are in place both for the prosecution and the defense? So just like in a trial, I shall first hand it over to Mr. Pramod Kumar Dubey, who with his experience will be able to throw some light from the prosecution side as to what is in store for us criminal lawyers. Mr. Dubey, thank you very much for joining us. Yes, Mr. Dubey.
Thank you, Lakshmi, and good afternoon to
Thank
everyone.
you, sir.
My senior colleagues, and the budding lawyers, and the member of the legal fraternity and the business class. Thank you so much and providing me opportunity to interact with all you on this topic that's a social, the balancing between social, basically the social distancing and the criminal trial. This is a very interesting topic as on date because after the lockdown and that's a COVID. So since March last week 2020, the courts are not working and the courts are facing a lot of problems. Though we have a lot of pendency, so every time we have the pendency, and but other side the matter is not going on. The court are not taking the matter. So the question is how we are going to balance between the right of the accused and the prosecution and the judicial delivery system. So we all have to balance and we all have to basically give our opinion how we should proceed further. Because the thumb rule is the delay in justice and delay in denial. We are already facing the delay in the criminal trial and we have a lot of pendency. Now we are not working for last more than a month or two. So first, we have three tier of the courts in India. That's the Supreme Court, High Court, and the Trial Court. All the three tier courts, all the three forums has the different kind of the proceeding. In the Supreme Court, there are different kind of the proceeding that is based on the pleading and the argument. So there won't be any problem in advancing your argument and conducting the hearing through the video conferencing. So far as the High Court is concerned, the High Court, we have the original side, the High Court sitting in Delhi and Bombay, unlike the other high courts. So we have the appellate courts and the original courts in the Delhi High Court. So appellate court has the altogether different proceedings because in appellate court you have to argue the appeal and appeal is based on your memorandum of the appeal. So in that eventuality you can argue the appeal and there is also the notification of Delhi High Court. I don't know about the other high courts. The Delhi High Court has passed the notification that if the convicts are inside the jail for more than 5 years and it's an old case, you can argue the matter by supplying the 5 pages notes well in advance and giving the judgment upon which you are relying upon, and you obtain the consent of the opposite party and you argue the matter. Now the Delhi High Court has started hearing the arguments on the appeal and the urgent matter. Now we are concerned with the trial. How we will balance the social distancing and the trial? It is very difficult because the criminal trial is altogether different from the civil trial. Because the civil trial is confined to the civil pleading. You have to complete the pleading, then the admission and denial, the framing of issues. Then you will file the evidence by way of affidavit, and then the cross-examination, whether in the court or through the court commissioner. So you won't find much problem in the civil trial, but in the criminal trial there are so many problems. And the criminal trial basically there are two major stages. One is the investigations and another is the prosecution. Prosecution means the filing the charge sheet. So filing the charge sheet, you can file the charge sheet after preparation of the charge sheet. So what is advisable at this stage? That the charge sheet must be prepared in a soft copy. There must be the e-copy of the charge sheet, immaterial whether the documents are voluminous or not, and there must be the supply of the charge sheet in both the modes. That's the hard copy as well as the soft copy. Why hard copy is required? Because if the accused are in custody, so the accused does not have the infrastructure to go through the document while he's in custody. So it is better to provide the hard copy so that the accused can go to the scrutiny of the document and he can give the instruction to the lawyer. And the soft copy is also beneficial for all the things. What is necessary as this juncture for the preparation of the charge sheet? The documents should be prepared, that the scanning should be done in the, basically the color copy scanning should be done, because in the color copy you will be easily able to find out whether the ink and everything and the nature of the document, because in the black and white it is very difficult. And the criminal proceeding is admissibility of the document and the admissibility of the evidence are very important things. Suppose the documents are not original, documents are photocopies, so you never know. So once you have supplied the document, it is required that you inspect the case code file, make the chart, and it is also there should be some amendment and the direction that the charge sheet should be filed, and there must be mentioned by the prosecuting agency whether this document is the photocopy or the original document, and they should give the source of the document, whether documents are original of the documents are available or not. So these kind of the documents should be passed so that it will be. Second thing, that the admission and denial of the documents. If you admit and deny the document under section 294, the counsel for the and the party for the litigation, that is the prosecuting agency and the defense counsel, admit and deny, that would reduce the burden of examining the witnesses. Once there is admission and denial, then the exhibit would be put and the court will consider the document. So the admission of the denial of the document should be very fair and very honest. So it is the duty of the legal fraternity, that's the part of the administration of the justice, the defense counsel and the prosecution, to come forward and admit and deny to reduce the burden for them going through the rigors of the trial. Third thing, you can argue the matter, that's like you can conduct the supply of the document, a scrutiny of the document by way of the video conferencing. For that, your physical presence is not required because the document has already been given to you in hard copy as well as soft copy. So you can conduct the scrutiny, you can move the application by way of filing the e-application before the court concerned, and the court can pass the order of direction supplying the document. So you can basically complete your documentation thing. So far the argument on charge is concerned, you can also make the argument on the charge. But the problem is at the time of the framing of the charge, the presence of the accused is required. It is mandate of the law that the presence of the accused must be there, and accused should understand the charge and then plead guilty or not plead to guilty or claim the trial. So this is the problem, and this problem is called because in conspiracy cases and where there are more than 5 or 6 witnesses, accused persons, so it will be very difficult to maintain the social distancing, because in India and the most of the places you won't find very big courtroom, unlike the High Court and the Supreme Court. We have the very small courtroom, and if the number of accused are more than 10, 12 and 15, so there would be the representation by the lawyer and the assisting counsel, so you cannot maintain the social distancing. So in that eventuality, we have to come with some via media like the digital signature of the accused, or the counsel can put the signature on behalf of the accused, because there is one judgment, Basra's R. Patil versus State of Karnataka, that is 200 in the year 2000. The Supreme Court passed the judgment. The accused was in USA. It was not physically possible to him to be in India. The Supreme Court passed his 313 statement can be recorded through the counsel. So the statement was recorded through the counsel because under 313, the statement of the accused is recorded without oath. So even the accused can consult the counsel, and even the copy of the questionnaire, which is incriminating evidence to be put to the accused for his explanation, can be supplied to the accused well in advance, and accused can give the answer, and that can be given through the e-copy. So you can also conduct the 313 proceeding. You have also some petty cases like the motor accident, challan, all the things. 32% of the litigations are related to the petty offenses. So motor accident claim, you don't require to present in person to deposit the fine. It can be deposited through the e-mode. So that will reduce. The second thing is the Negotiable Instrument Act. We have the volume of the cases related to the Negotiable Instrument Act. The Negotiable Instrument Act is basically the summary proceeding, and the notice will be framed under section 251 CRPC. So if you plead the guilty, then the matter will be, if you plead not guilty and claim to be trial, in terms of section 145 of the Negotiable Instrument Act, then the matter will be put for the trial, and that trial would be the summary trial. So in that eventuality also, you don't require to be present in person. the trial can be conducted in absence of the accused. So these are some area where you can easily go with the video conferencing. But video conferencing, there is a major problem, that the major problem is the infrastructure. We don't have the proper trained court staff. We don't have the proper trained the lawyer, because see, we are practicing in the metropolitan area, so we are well equipped with all the internet and all the video conferencing things and the internet. We have entered into internet, but if we have the lot of courts which are situated in the rural area and the far away area, they don't have the infrastructure, because we have around 14,429 courts all over the India. And there was one judgment of Delhi High Court in 2000, where the Delhi High Court passed some observation. This judicial system is meant only for the rich people, and their poor people have been deprived from their access to the judicial system. So, pursuant to, there was a question in the parliament on 24th February 2011, when Mr. Birappa Moily was the law minister. And it came from the side of the government and the ministry that a sum of rupees 935 CR has been allocated to convert 14,229 courts in the eco. But that has not been executed yet. If we are practicing mostly in Delhi, if you go to the NCR, even to the NCR like the Jajjar and Panipat, Sonipat, and some part of the Rajasthan or the Uttar Pradesh, you will find even as on date, there is no infrastructure in the court. The court masters recording the evidence with their hand. So we have lack of infrastructure. They don't have the computer. I had experience when I appeared in one matter in CBI, a special court CBI in Lucknow Court. This was the special court CBI, but unfortunately there was no printer in the court. So what the court staff did, the order was dictated, then order was taken into the pen drive, it went to the computer of the district judge, then the print was taken out. So this kind of the problem we are facing. So we cannot resolve all this problem in overnight. It'll take time, it'll take the proper administration, proper guidance, proper training, because your court staff, even the Almat is the record keeper. So they are not trained how to maintain, how to keep the e-record, how to supply all these documents. So they are not aware, the judges are not aware, the lawyers are not aware. Most of the lawyers who are from the rural background, they come to the city for the practice, they don't have the access. The one more problem, like unlike Delhi or Bombay, there are some states where the electricity is supplied for the limited period, like the 6 hours, 8 hours, 7 hours a day. So electricity is also important. If in UP, suppose there is a electricity cut from 10 AM to 4 PM, that is the crucial time for the conducting the court. So you won't able to put all these things on the motion. So there is a lot of problem. So we have to see the problem, and then we have to come the informity so that that would be a smooth functioning of the judicial system. Merely we are crying that is the problem and we can go through the video conferencing, that is not going to solve. We have to pass through the lot of hurdles, and the hurdles are there. Like suppose you have already done advanced the argument on charge has been framed. The question would be the recording of the statement of the witnesses in criminal case, and this is very crucial. There are so many types of the witnesses, like the formal witnesses. You can conduct the examination of the formal witnesses. Expert witnesses you can do. There is no problem. But so far as the material witnesses and the witnesses to the recovery of the exhibits, like the weapon of the offense, in the trap cases, the person who was the member of the trap team. So if the weapon of the offense is being produced, unless and until you are physically present, you cannot identify. You have also seen whether the seal is tempered or not, what kind of the seal is there. So it requires the physical verification by the defense as well as the prosecution to see the sanctity of the case of the prosecuting agency. Like in one case I was conducting, that was a CBI matter, and they examined one driver, and driver was there to prove his logbook to the effect that he was on duty from such and such period, and he was on the secret mission from such and such time, and he visited such and such places. So they filed the logbook. The logbook, when I was going through the cross examination, I thought I should go through the and examine the original. When I examined the original, I found that the entry was in the different ink and different pen. So immediately I put the question to the witness. Yeah, I'm putting to you, this entry was made subsequently in a different pen and different ink at the instance of the CBI. The witness says, yes, you are correct. When I was called to the CBI office, I was made to make this entry at the instance of the CBI at the subsequent stage. So this is the very crucial things, because unless and until you see the document in original form, you will not be able to conduct the proper trial. So for trial, the physical presence is required. But on the other way, if the number of the accused was so huge, like I'm doing the Bhushan Steel SFIO matter, there are more than 200 accused persons. Just imagine in a small room, and there are more than 200 accused persons, how you maintain the social distancing? More than 200 persons will be represented through their counsel. They all required to be present. So it is not possible. Even in other society matter, other society bank, SFIO matter, others matter, there are more than 150 accused persons. So as per the number of, when we are doing the court block matter, there are a number of accused persons, because it's the case of the conspiracy. Even the accused persons are not getting the space in the court. Because in the court, if you are conducting the trial through the physical presence of the parties, you need the defense counsel, you need the accused persons, you need the prosecuting agency, you need the parvy officer, you know, the IO, holding IO, and the court staff, and you don't have the sufficient accommodation in the courtroom. So you cannot maintain the social distancing. You have to violate the social distancing if you are going to conduct the trial. And one side is the problem. The second side, if you are not going to conduct the trial in the physical form, so your accused would be deprived from his right for the fair trial. The trial would be simply the eyewash. And third thing is very important. When you are cross-examining the witness, if you are present in the court, you are able to see the screen on which the stone is typing. So you can make the correction. If the correct sentence is not coming and the screen is in front of you, you can make the request, you can make the correction then and there. Because unlike the European country and other countries, we don't have that kind of the infrastructure. Because I recently appeared in a arbitration matter in Paris. The cross-examination was going on, and parallelly there was a transcription. And the transcription was so fast, it was with the speed of the cross-examiner and the witness. So we don't have that kind of the infrastructure, because our steno, they have the maximum speed of 80 per minute and 86, 80, 90, maximum 100. So this kind of the problem you are going to face while cross-examining. Third problem is there are so many matters like this, your family matters. Suppose you have the rape matter, the POSCO matter. These all would be recorded if these matter related to the Official Secret Act. So if this all information would leak in the public, so that would be also cause the prejudice to the state, prejudice to the party, and there is a possibility of hacking of the information. Because I was conducting the one seminar and my site was hacked and some incriminating material was put. So we don't have that kind of check and balance. We can basically check that and rule out there won't be any hacking, and there would be the sanctity of all the materials. Third thing is very important. if you adopt the video conferencing and e-court everywhere, so you need a digital signature of the persons and the honest disclosure from the parties. Because if you make the honest disclosure in the court, so your disclosure would be taken as a gospel truth and the court will proceed the entire proceeding. But it is not possible, because in India, if you have not given the dishonest disclosure and your disclosure is a mala fide, you have intention to mislead the forum, there is no check and balance. Though we have the law of perjury, but in India, the perjury law is a toothless tiger which cannot bite. The people does not have fear from the perjury. So you have to make the strong amendment. You have to make the stringent provision for the perjury. Whatever you are giving, what you are stating, whether you are document filing, the certifying the documents, that would be taken the gospel truth and you would be punished then and there. We have very long proceeding for the committing of the perjury. So you have to strengthen the law of the perjury if you are totally going to rely upon the e-court and the video conferencing, the trial, all the things. So these are basically the wide aspect. Second thing is that the investigation part. Investigation part, if you are going to record the statement under 161, that's recently the Punjab High Court has given the direction for the recording of a statement under 161 CRPC. So that would be again in violation of section 2425 the Indian Evidence Act. The recording of 164 statement, 164 statement cannot be recorded through the video conferencing because the court has to personally satisfy. The court needs the interaction with the maker of the statement. Yes, to rule out whether the statement is made under duress, pressure, coercion, or all these things. So there are so many things. You need so many amendments or the judgment of the Supreme Court on each and every aspect. Because if you are going through the video conferencing, you are relying on the e-evidence, then you require the certificate under 65B. This is also the problem. So it's a very complex thing. It is not easy that you can conduct the criminal trial through the video conferencing. You can do certain things, but you cannot conduct the entire criminal trial by way of the video conferencing. There are so many problems, so many complexity in the video trial. So, suppose you will come with the law will come into force, then that will be applicable for the matter which are under investigation. But the matter, suppose the matter which are already pending. So what the measure you have? You don't have the e-copy of all the documents. You don't have the show material of all the documents. Though in 2003, there was a radical change in the recording of evidence in the matter of a state of Maharashtra versus Dr. Praful B. Desai. The witness was in USA. He was not able to fly down to India. So the Supreme Court passed the direction his statement can be recorded. There are certain judgment of a Calcutta High Court also where it has been directed that the statement of the witness can be recorded through the video conferencing. But again, the problem would be, suppose there is a TIP. The TIP is the most crucial defense of the accused persons. But if you are going to the TIP through the video conferencing and you are showing the witness one by one accused, so basically you are prompting the witness. You are inviting the problem. I have just conducted a POSCO matter in a Muzaffarpur shelter home matter where what happened? The accused was put on the video and he was said, tell this is the person. So there was a prompting. This was not the fair. So there won't be the fairness. Because the criminal law, the genesis of the entire criminal law is the fair hearing. No person can be deprived of his personal liberty except in the procedure established by law. And we don't have the law. because we have the open court theory under section 327 CRPC. There is an exception for the rape cases and the POSCO cases. So you have to change the entire setup. You have to make a lot of amendment in this field. Then you can proceed further for conducting all the things. So this is not the overnight. So if you want to continue the criminal trial while maintaining the social distancing and balancing the criminal trial and the social distancing, you just go for the schedule. Both the party fairly admits, yes, we want to cross-examine this witness or not. What would be the timing for the cross-examination of the witness? It should be basically decided well in advance. Who is going to cross-examine first? What would be the period and duration of the cross-examination so that the second counsel will come and he will take over? Though this is also against the principle of the natural justice, because suppose I just started the cross-examination and I have put certain question which is incriminating to my co-accused. So he's the right to raise the objection and cross-examine the witness. So his presence is also required. So these are kind of the problem which we are basically apprehending when we are going absolutely with the going to the trial absolutely with the video conferencing. So the physical presence is very necessary. I have one matter. I am going to argue the matter. The cross-examination of IO is more than 200 pages, and all the questions are very relevant. If we follow the direction of the court, it is not possible for us to file the 5 pages written submission, because each and every argument is very crucial. So we need a physical argument in the physical form by physical presence in the courtroom. We have to show so many documents, and there are as many as 3 accused persons, and there's a battery of lawyers. So you cannot basically cut the right, shorten the right of the accused persons. You have to balance the right of the accused, balance of the state. Merely on the guise of the video conferencing, the e-court, you cannot deprive the person from his right. So you have to do so many things. I think I've already completed. Mr. Shinde is there. Mr. Shinde, good afternoon. And I'm very privileged that I share this forum as one of the speaker. I am very thankful to you, Mr. Shinde, and it's over to you. Thank you so much, Mr.
Thank
Shinde.
you, Mr. Dubey. Hi, friends. I'm not formally dressed as Mr. Dubey, and since we are on more of a vacation time, working from home, I thought it's easier to address you as friends, and so here I am. I've heard Mr. Dubey and very thoughtful insight into all the aspects that he has dealt with criminal law under video conferencing. And with the new technology that we are coming to use because of this force situation, the Supreme Court was called upon to pass an order recently in urgent matters, taking into consideration the COVID policy of social distancing. And Supreme Court was pleased to say that the proceedings in the High Court and in the Supreme Court will be on a video conferencing, whereas the proceedings in the trial court would be on video conferencing provided both the sides consent to it. That's why the Supreme Court realized that there are basic problems in holding a trial court proceeding on video conferencing, particularly in view of social distancing. The first matter where the Supreme Court dealt with video conferencing facilities and trials to be conducted by video conference was in the case of Sanghi, where the Bombay High Court had ruled that video conferencing in a criminal trial was not possible. And because the witnesses in that case were medical experts residing in the USA and they were not amenable to the jurisdiction of Indian courts. But the Supreme Court, headed by Justice Variava, the bench that was headed by Justice Variava, ruled against the Bombay High Court order and felt that if a trial has to be conducted in the presence of the accused, could be meant on virtual courts, particularly where a person who was going to depose was faced with a lot of restrictions in the sense and conditions. And one of the conditions that was placed in that order was the person who was going to depose in a virtual court would be in the premises of the Indian consulate or before a notary public or in the presence of a court officer, and the accused would be present in the court or the jail premises on a video conferencing. In such matters, video trial could be conducted. Whereas there are basic difficulties, like Mr. Dubey said just now, that in proceedings before the High Court and the Supreme Court, where there is no witness action, particularly in criminal matters, there is no need for us to rely on witness action because there's no scope of leading any evidence. Whereas in trial courts, there are basic difficulties. There are phases in which a video conferencing trial could be conducted. For example, like framing of the charge, though Mr. Dubey said that the physical presence of the accused is necessary, trials are being conducted in Bombay where the accused are in jail and are explained the charge on a video conferencing in the premises of the jail. And thereafter, the trial could proceed. But prior to the charges being framed, the copies of the charge sheet need to be provided under section 208 to all the accused. And at which time, the physical presence of the accused may not be necessary. But for the purpose of verifying whether all the documents are furnished and whether all the documents as per the charge sheet are in numbered properly, are legible properly, are all these factors which cannot be asked on a video conferencing. That's one difficulty. Secondly, an accused would want to compare the documents in the court and the documents that are provided to him physically, which also means that the accused will have to be given access to these documents in a physical form. For that purpose, social distancing may not be possible because the documents cannot be handed over to the accused in his custody because there is always a fear that certain clients who are now much more well-versed than most of us can destroy or eat up those documents. In many cases, like Mr. Dubey says just now, that most of the cases depend upon documentation these days in economic offenses and SFIO cases or PMLA prosecutions. So in such case, if the accused insists on a document to be furnished to him for the purpose of comparing and whether he wants to verify that the signature on that document belongs to him or to some other person, that document cannot be handed over in his custody without taking into consideration the social distancing norms that are today. Because if the social distancing norm of 2 meters is to be maintained, the document would have to be given in the custody of the accused, where the prosecutor or his officers or court officers will have no control over the accused tampering with that kind of a document. It may be possible that the court may ask the accused to do it personally in presence of the officer, but if there is no social distancing and a chance to retrieve the document from the accused when he is trying to destroy the document, it's not possible. Similarly, when a trial is being conducted, it is possible that when the prosecutor opens his case before the examination of witnesses, that portion of the trial can be conducted on a virtual court or a video conferencing. Whereas once he starts leading evidence, the accused may insist that one of the reasons that all the time it has always been mandatory that the trial must be conducted in the presence of the accused in the physical form in the court meant that the witness should depose in the presence of the accused. It so happened in my one case that Arun Gauli, who was prosecuted for an offense of murder, was being tried. And when the witness came to the court, the witness happened to be the father of the accused, father of the victim, and he happened to be a senior lawyer in the Sessions Court in Bombay. Arun Gauli's men, it was alleged, had picked up the lawyer's son from his residence at about 4 o'clock in the morning, dressed as cops, and one of the persons in those 4 people was alleged to be Arun Gauli. But when the trial came up for evidence, the judge asked the witness to look at the accused and point out who Gauli was, because he had to identify each accused person. The witness said, "Sir, by being so strong so far, me and my family have lost one son. If I look at accused and I am going to identify, and if I were to identify, me and my family will not be left on this Mother Earth." So, because he knew that if he looked at the eyes of the accused, he would not be in a position to lie. It was very easy for him to look at the judge and not look into the eyes of the accused and make a statement which was totally contrary to what he has said in a police statement under 161. Because in the 161 statement, he was the only person who had identified Gauli. That's one aspect of the matter. The other aspect of the matter is that the accused insists in a particular trial that the witness should depose in presence of him, because it's always a known rule or a natural conduct of a person that if you were to look into the eyes of the person and make a statement, you're not likely to lie. That's why, in all these romantic stories in the films, you will find the hero telling me, "मेरे आंखों में देख के मेरे को बताओ कि आप सच बोल रहे हो कि झूठ बोल रहे हो. Look into my eyes," if you all can remember that one song. So similarly, it's a general belief right from thousands of years that if you were to look into the eyes of the person before whom you're deposing or before whom you're making a statement, you're not likely to lie. That's why if you look into the philosophy of a trial being conducted in the presence of the accused, you may get some aspects of it that the human tendency is not to lie when you're looking into each other's eyes. So that's a handicap that you will face in a trial on a virtual camera, where a person who is sitting thousands of miles away and conducting a trial on a video conferencing is likely to lie. Because it has so happened to me in one of my cases that I was dealing with an arbitration case in connection to the Leelavati matter. And in that case, we had about 3 experts from Belgium who were supposed to depose on the conviction of one of the trustees of the trust. So when it came to the statements that I had to confront with them, they realized they were caught on the wrong foot and they stopped coming for the trial on the next day before the video conferencing. Or even what happened in that trial was that on the first occasion, the person came to the Charity Commissioner's office. On the second occasion, he said that he had no time and he left India, went back to Belgium. So we held the trial on a video conference from a 5-star hotel. During those days, there was no possibility of getting a video conferencing like we're having now because the technology was so obsolete. It was about 15 years back. So when we held the video conferencing trial, the person refused to come on the screen. So it was a matter where I wanted to get answers which were in my favor on a video conference. But the very fact that he did not come on a video conferencing trial meant that I lost the chance of getting the admissions that I wanted in a civil trial from that witness. So there's both a handicap and an advantage to an accused in a criminal trial. It's a fact. It is a fact that if a person does not come on a video conferencing trial from the place where he is deposing and deposes only in the examination in chief, the examination in chief, the evidence recorded either in a physical form or on a video conferencing would not be admissible unless it is tested through cross-examination. So therefore, there is both an advantage and a disadvantage. It is also possible that from a witness, if you want to extract the best answer, many a time you will get a chance to cross-examine a witness so that he will give you answers which are supporting the accused because they are factual. Many a time you will find that the witnesses will not be in a position to deny the fact if you confront them with facts. Therefore, it's both an advantage and a disadvantage in accused. These are the factors which are particularly, intrinsic in conducting a trial in the physical form instead of a virtual court. Then comes Mr. Dubey's essence is a prosecutor. Many a time he will have to take secret information from the officer about putting a few questions to a witness, which he could think that they are very germane to the prosecution. At which time, he will have to whisper in the ears of the officer and ask him to whisper in his ears about the answer that he is likely to give him, without the accused or the defense lawyers learning as to what was communicated and what was going to come before the court through the witness's statement. But if a person were to observe social distancing, either Mr. Dubey or me as a defense lawyer will not be in a position to get those secret or informative instructions which are not necessary for the ears of the other person in the courtroom. Apart from that, you will always realize that we lawyers, we like to be briefed by the person who is conducting the trial as an advocate on record if you are appearing as a counsel, or the prosecutor would also need instructions from the officers at various stages of the trial. If social distancing were to be maintained, every now and then he has to obtain the court's permission to go out of the courtroom to obtain those kinds of instructions, which he thinks are not to be heard by anybody else other than him. It's meant only for his ears. So these are the problems that one would face in a virtual courtroom. Apart from that, one of the points that was raised by one of the participants here is that if it's going to be open court, how will a virtual court be accessible to a common man, and how can they view the court proceedings? Unless the court proceedings are open, like we have today on a Zoom meeting, where hundreds of people can register themselves and participate. If such a facility is not available to the general public, or if the proceedings are not streaming on a TV or a video, it's not possible to be an open court. It will lose its efficacy of an open court, and it would be as if it's a court in camera. Therefore, these are some of the difficulties that we're going to face. Apart from that, the proceedings that can be conducted in a virtual courtroom are only arguments, or like Mr. Dubey said, that if it is a 313 statement and there are hundreds of accused in a trial courtroom, it's not possible for a judge to have that kind of interaction on a virtual court with each accused every now and then. If he has to conduct a virtual courtroom on the basis of 100 to 150 accused being tried in one trial, it is not possible for him to devote so much of time. Apart from all that, we have the basic difficulty in the infrastructure. The infrastructure that we have today is totally insufficient for carrying on a trial with social distancing. Apart from that, the technological arrangements that are to be made in an open courtroom, like the sessions court or in the trial court, is going to be enormous. And the kind of money that is going to be spent will be much larger on the economy. And I do not know if the power shortage that is in most of the rural areas, particularly in the summer, if it prevails, how will our trial courts function? It's all right that the Supreme Court and the High Courts pass orders under the jurisdiction or suo moto, calling upon the state government to see that the judiciary in the High Courts and in the Supreme Court does not come to a standstill. But we have more than 40,000 courts all over the country, more so in the rural areas. Every taluka has a court or two. And with so many e-courts coming into function, whether India is prepared to put that kind of amount of money in setting up these e-courts will be a matter which is debatable. With all these difficulties, I feel that the points that are covered by Mr. Dubey and by me would only tell us that it will be a Herculean task for us to have a virtual courtroom, have a video conferencing facility so that we conduct trials. In many cases, it so happens that if there are 100 to 200 accused in one case, those 100 to 200 people will have to be on a screen where the trials are going to be conducted. We don't have that kind of facility to provide 200 screens or put those accused in a large courtroom in the jail premises so that they can all watch the proceedings when we lawyers conduct the trial on their behalf. Apart from that, some of the difficulties which Mr. Dubey narrated are very germane. If you have to point out documents to a witness and ask him a pointed question with particular reference to one word that is written in a document, and if the witness is far away in the US, it is obviously impossible for me to conduct a fair trial to point out any discrepancy in that kind of ink or in that kind of material that is used on a paper. In one of the cases that I was trying, there was a document which was a will, which was produced in the court. And that document was forged by the help of traced forgery. What the accused had done was that he had taken a piece of paper, traced the signature on a document, and embossed it on a document and making it a will. So these kinds of documents, which are to be viewed in light, cannot be viewed in a virtual courtroom. It has to be in a physical form where the trial has to be conducted, where there will be a lot of problem in adhering to the social distancing and the COVID policy that the government is imposing. So unless a friend of mine who is now busy in production of a vaccine is successful in the next couple of months, we are not going to be in a normal courtroom for a long time. So with these views of mine, I will conclude for the time being because Madam Lakshmi has said that there has to be a question answer format so that people are free to ask a few questions, not just sit as silent spectators and go back home.
Thank you, sir. Thanks a lot. That was an extremely insightful talk. Apart from the aankhon mein aankhein dekhna, we'll also, I'm sure, face hurdles with respect to the demeanor of the witness if they are not in front of us, like say if they're shaking their legs or something in case they're nervous. But very well put, sir. Thank you so much. We have a question. We'll start a question and answer round. Mr. Dubey, we'll first start with you. There's one question that has come up for you with respect to technology in courts. Considering cybercrime is on a rise, can courts rely on technology without any security breach? And whether recording evidence through video conferencing is admissible in law?
Yeah, Lakshmi, the problem is the security. I have already mentioned the security. How the court is going to rely upon the evidence if there is no security of the document? So cyber crime, it will basically encourage the cyber crime. and the theft of the material, theft of the information, hacking of all the things. So you need proper software which will rule out any kind of the tampering in the document or hacking of the document, theft of the materials. Unless and until there is a sanctity of the materials to be relied upon by the parties, the court cannot rely upon. That's why there is a judgment to you give the certificate under 65B. You are giving the certificate under 65B. Okay, you are the party, you are giving. But what is the... So you need full guarantee, and you need one thing also, you also need informed software for everywhere. You don't have that kind of the software to run all the courts everywhere. You need a pan-India software so that you can do, because suppose there is a different software, different kind of the practice in your state. Like suppose, like Mr. Sinde has mentioned, the supply of the hard copy to the accused. In Delhi, we have the practice if accused in the custody, and if he's making the request to carry the hard copy of the charge sheet with him to the jail, he is permitted. Even in the Bhushan Steel matter, the SFIO matter, one of the accused, Mr. Nitin Jawahari, is inside. The documents are voluminous document. That's a more than 60,000 document. He made the application before the court. I may be permitted to carry the document. The document was provided to him and he's carrying. In other matter of mine, that's the OS Act. So document, hard copy was given to the accused, and accused carry the document in the jail.
Yes, sir, that's right. Our next question is for Mr. Maneshinde. So under the Commercial Courts Act, we have a case management hearing that plans how a civil case or a trial is to be conducted. Do you think it's feasible to have a case management hearing in a criminal trial or at the stage of arguments on charge, so that unnecessary physical hearings can at least be done away with and video and physical hearings can be compartmentalized?
You see, that's one of the reasons why the Supreme Court said that in the recent order where it mentioned that under the COVID policy, the trials will be conducted only on video conferencing. Unless both the sides consent, those formats of the trial court, as in the commercial courtroom, cannot be conducted. But you know, in most of the cases, we defense lawyers will never agree with the prosecution, and the prosecution will never agree with the defense. So that tussle will always continue.
Absolutely, sir. Mr. Dubey, we have another question for you. In regards to your comment on the lack of infrastructure in rural India, do you think use of telephone or mobile phones instead of video conferencing in rural areas where internet hasn't reached could help to an extent?
See, even if you are carrying the smartphone, mobile phone, you can easily participate in the proceeding. There is no problem. You can participate, but the question again would be the software, whether you have the software or not, whether you are familiar with that software or not. Because there are so many difficulties in the handling the software. So the question is the software, number one. Number two, suppose you have more than 100 accused persons. More than 100 accused persons are sitting at the different places. Because as is rightly pointed out, Mr. Sindar, that there must be the presence of the accused. The presence of the accused is not only to secure that he is not fleeing from the justice. The presence of the accused in the criminal trial is also required to instruct the counsel. The presence of the accused is required if the counsel required any kind of the instruction, so he can immediately consult the accused. So if you have the mobile phone number, you can easily use the mobile phone. There is no problem. Right, I don't see any problem in using the mobile phone while you are in the rural area.
Okay, sir.
So the courts will have to change its attitude towards mobile phones being used in a courtroom.
Yes.
Yes, absolutely.
Absolutely.
Mr. Maneshinde, we have one last question for you. It's a very interesting question. In order for the courts to conduct proceedings and more particularly trials over video conferencing, would it not be necessary for the legislature to first enact an enabling statute simultaneously with overhauling the procedural laws, or would the rules of the High Court, that the rules that are framed by each High Court itself suffice when
See,
we combine it with the IT
now,
Act as well?
just now we have the Supreme Court judgment of Justice Variaba permitting trials to be conducted on a video conference. Apart from that, with all these technicalities about recording and maintaining an e-copy of the record, the presence of the accused, the oath being administered to witnesses outside the jurisdiction of India, all these factors will have to be considered. And I think there will be a new comprehensive law to be framed by the Parliament so that in future we do not face any difficulties in the event we were to face certain difficulties in conducting a trial because of these social distancing norms.
Absolutely, sir. We shall hope and await the
Yeah.
Parliament forms these rules. Thank you so much.
Or a vaccine produced by various all over the world.
Absolutely, sir. Let's hope so.
Yeah.
I'd like to thank both our speakers today for joining us, Mr. Satish Maneshinde and Mr. Pramod Kumar Dubey. It was a wonderful, extremely wonderful discussion, extremely insightful. Special thanks to Mr. Nipun Bhatia from Legally Consulting for helping us set up this webinar. And I thank all your participants for joining us today. Stay safe and have a good evening. Thank you.
Sorry that we kept all the participants away from their afternoon siesta.
One thing I would like
they can get back to
Lakshmi, I'm sorry. One thing I would like to mention here, because if you are going for if the government is proposing and the Superior Court are proposing for the video conferencing trial, so one thing should also be kept in mind, because that's the bail thing. The law on the bail should be liberal, because you cannot overcrowd the jail, because there are three types of the bail. One is the anticipatory bail, other is the arrest during the course of the investigation, third is the bail upon your presence before the court. We have one judgment of our own High Court. There is a court on its own motion passed by Justice J.D. Kapoor, and the two other subsequent judgment where in one of the judgment I was the amicus curiae. The Delhi High Court has passed the direction to all the subordinate courts, if the accused persons have not been arrested during the course of the investigation, the charge sheet has been filed without arrest, the accused person should be released on the bail. So if during the course of the investigation, they have not been arrested, they appear, they were taken into custody, there is no need to put them into the custody, let them be outside. So you have to liberal on the anticipatory bail, unless and until it is imminent to arrest the person. Merely the offense is the non-bailable and cognizable, you don't arrest the accused person in the routine way. So this is the one aspect. The second is the court has to be liberal on the exemption part also. The court should not insist the accused just to satisfy the ego or some other purpose. No, accused must be present in front of the court. If the physical presence of the accused is not required, then he should also be exempted. That these two aspects will also help in the video conferencing and the virtual court. So my suggestion is also that the Superior Court and the Parliament and the legislature should also consider on two aspects. Thank you so much.
Thank you.
Absolutely, sir. Thank you. Thank you so much for joining us today.
Okay. Bye.